Hello, Craig DeLuz here, coming at you live from the FPC newsroom with some breaking news regarding a very important Second Amendment and First Amendment case here in the state of California. Some of you may have heard of Tracy Rifle and Pistol v. Harris, but in case you haven't, well, let me get you up to date on exactly what the case is about. Check it out.
Tracy Rifle and Pistol v. Kamala Harris is a case that's focusing on a unique advertising restriction that California has in place. It's California Penal Code 26820, and in substance, it bars firearms dealers from displaying handgun advertisements either on the outside of their premises or that can be seen from outside the premises. So a handgun display or advertisement that's inside the premises but can be seen through a window.
My name is Mike Barilla. I'm the owner of Tracy Rifle and Pistol. We wanted to advertise, wanted to be obvious, that we're a gun store, gun range. So we put what most of our sales are, pistols, on the outside of the building.
Rob Adams here with Sacramento Black Rifle, located in Citrus Heights, California. Being in the industry and all the rules and regulations that us dealers are subject to. And then something like this, something as, advertising on the outside of a building, as tough as it is, our business is already trying to get the message out of what we can and cannot sell.
I'm kind of just like anybody else. I don't like my rights trampled. This is, not only the Second Amendment, but you got obvious First Amendment issues here. If I can't put a picture of a handgun on a gun store, that's just beyond ridiculous.
Yes, it is beyond ridiculous that you would not be able to do that. Now, you might think that this is a result of some modern day anti-gun, gun control legislation, but in actuality, it's not. This particular law was put in place in 1923. It was a part of AB 263, otherwise known as the Hawes Act. Now, the Hawes Act did a number of things. For example, it instituted the waiting period in order to be able to purchase a firearm. It also instituted the may issue concealed carry permit process that we currently have here in California. So those are just a couple of things that were done by the Hawes Act in 1923. What else it did, and this is the legislation we're talking about right here. It did this. This is the actual language. It says, no pistol or revolver or imitation thereof or placard advertising the sale or other transfer thereof shall be displayed in any part of the premises where it can be readily seen from the outside. Now, that is the Hawes Act back in 1923. Now, today, that same law is reflected in Penal Code 26820. And here is what that says exactly. It says no handgun or imitation handgun or placard advertising the sale or other transfer thereof shall be displayed in any part of the premises where it can be readily seen from the outside. So that kind of gives you a really good idea of kind of where it came from and what it looks like now. So let's fast forward to 2014. 2014, Mike Barilla, owner of Tracy Rifle and Pistol, was fined because, as you saw, he had pictures of handguns on the outside of his store. Interestingly, they were right next to, in some cases, pictures of semi-automatic long guns right next to them. The long guns, though, were not illegal, but the handguns, in fact, were. So he got fined. Also, another individual who had gotten fined at the time was the owner of 10% Arms. His name is, where's he at? Wes Morris. Wes Morris was the owner of 10% Arms. Right? He was also cited. You also noted in there an individual from Sacramento Black Rifle. If you notice, now here was the interesting thing about his situation. It wasn't like there was this big picture of a handgun. It literally is a handgun in the name of their company. In Sacramento, the R is actually a handgun. So these folks got together. They reached out to Brandon Combs, who was at the time the executive director, actually still is the executive director for the Calguns Foundation. This was also in the very beginning of the California Association of Federal Firearms Licensees. FPC was still in its infancy at this time. So these folks got together and reached out to the Second Amendment Foundation, and together they also partnered with PRK Arms and owner Jeff Mullen. Let's see, anyone else here? Oh, Alex Roloski of Imbert and Smithers, and once again, and their co-owner, Alex Roloski. They all got together and they sued then Attorney General Kamala Harris. Well, 4 years later, you guys hear me? 4 years later, we finally have a ruling on this particular case. Can you believe it? We finally have a ruling on the case. Yesterday, Federal District Judge Troy Nunley issued a decision that held that the state law was unconstitutional, all right, and ordered that it could no longer be enforced, meaning it was enjoined. And I think what's really telling about some of the things that he said, and this will really speak to a number of the different things that we're going to be dealing with going forward. So one of the things that he noted, we'll put right here, said the Supreme Court has rejected this highly paternalistic approach to limiting speech, holding that government may not achieve its policy objectives through indirect means of restraining certain speech by certain speakers. Now, what that in essence means is, you're not allowed to violate the free speech rights of individuals simply because you want to institute some sort of paternalistic objective that you're seeking to implement. In this case, and it normally they talk about the violation of certain fundamental rights. Well, in this case, we're talking about the First Amendment, and we all know that for the most part, the courts have held, and the Supreme Court has held the right to free speech to be very, very important. I mean, almost above any other rights. But the thing is that it's noting right here that you cannot tell someone, you cannot violate the free speech rights simply because, well, you're afraid that someone might impulsively go and purchase a firearm. Now, mind you, this is in a state that requires a 10-day waiting period. So there is no impulsively obtaining a firearm in the state of California, unless impulses last 10 days or 11 days, because most retailers will make you come back on the 11th day. But there is no impulse gun buying in the state of California. But they also kind of recognized how the state was to a certain degree hypocritical in this law and in defending this law. They noted that the plaintiffs could display a large neon sign reading "Guns, Guns, Guns," or a 15-foot depiction of a modern sporting rifle, and this would be permissible, highlighting how unreasonable and under-inclusive the law was. So in other words, if it's just about guns, well, guess what? We have the ability to put guns, guns, guns. We have the ability to do all sorts of things on the outside of the store. As you saw, right next to the picture of the handgun was a huge picture of a long gun, fully decked out with all of the cool toys and gadgets. But because it's not a handgun, well, therefore the law should not apply. So in the end, they wound up throwing it out. Now, I know a lot of you are wondering, why is this important, Craig? Why should I care about this particular case? Well, here's why. Because ultimately, as they seek to go after all of our ancillary rights, in this case, we're talking about the First Amendment, they're going after those rights specifically in order to keep us from being able to exercise our Second Amendment rights. They want to limit your right to freedom of speech so that you can't support your Second Amendment right or be encouraged to exercise your Second Amendment right. This is going to play a greater role in particular when it comes to outdoor advertising. In the state of California, there are a number of different signs or billboards that the state has handed over to control of local municipalities, and at the same time, they're forbidding them from being able to advertise firearms. Guess what? This could have an effect on those decisions, on that legislation. We have to understand that all of our civil rights are encompassed and that you cannot violate one for the sake of the other. The Second Amendment, in the eyes of many, is a disfavored right. And it's a right that we have to fight for. But as a part of that, you cannot take away our right to due process. You cannot take away our private property rights. You cannot take away our free speech rights simply because you don't like the fact that we want to exercise our right to keep and bear arms. That is why this case was important. This is why you need to continue to support the legal efforts of groups like the Cal Guns Foundation, the Firearms Policy Foundation, and the Firearms Policy Coalition. Because as you support these legal actions are going to support not just your right to keep and bear arms, but all of those other civil rights that are ancillary to it. Now, this was a district court decision. You can pretty much bet that Attorney General Javier Becerra is going to appeal this case to the next level. So we'll probably wind up in the Ninth Circuit. So we still need your support. Cal Guns Foundation, the California Association of Federal Firearms Licensees still need your support in helping us to fund the fight in order to keep this thing going. Just follow the link in the description of this video, this live feed, and when you go there, you'll be able to donate in order to help us fight this case. And all right, folks, thank you so much for tuning in. Thank you so much for supporting all of the organizations that are supporting your right to keep and bear arms. Please remember, this is a fight for our civil rights. We've got to use them or we're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.